The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show. So here you go. Barbara Howard at 960 Mercantile Center, 120 East 4th Street in Cincinnati, and Don Moore, of course, the Moore Law Firm, 1060 Nimitzview Drive, Cincinnati, 45230. You can get all that information on fox19.com and click on Moore Law. And we also want you to know that you can go back to fox19.com, click on Moore Law, and you can see all the shows we've done so far. So welcome back. Don, you had something you wanted to get to pretty quickly that you think folks should know.
Yeah, one of the things that we get asked quite often, or we're involved in cases where people actually, they have a terrible accident. It not only affects them physically, but it also is kind of the coup de grace for their marriage. And they wind up in a divorce court in addition to having an injury claim. So people have asked me before, what happens when those circumstances occur? Well, one, the injured person is the one that gets the lion's share of the settlement with respect to the injury. With respect to wages, it's almost like as if they earn the wages. Those are going to be divided according to the equities decided by the divorce court or agreed upon. And finally, as far as the loss of consortium, that's going to be the non-injured spouse, just as if they stayed married. Although, frankly, with a loss of consortium, that has to do with the love and affection and other things that one gets from one's mate in a normal marriage circumstance. One might say that if they're in a process of a divorce, that's not much of a claim. So usually that goes by the wayside. Barbara, have you had situations similar to that?
Sure. Whenever you've got a personal injury claim, you have what we consider separate property. So just as a gift or inheritance would be separate property that stays with the person who owns it, so would a personal injury claim for their pain and suffering. A spouse, if there is loss of consortium, and you're right, if they're in the process of a divorce, not likely there's much. But it would also be the spouse's separate property because it's theirs as a separate asset, not a marital asset. And the property, or the lost wages, is as if earned income. And unless there's a prenuptial agreement changing it under Ohio law, those earnings are marital, so they would be subject to property division.
And unfortunately, that circumstance just comes up all too frequently.
It does.
All right.
All right. Well, we have a few more calls we're trying to get to before the end of the show. We have Charles in Mount Auburn. Charles, you had a question about child support. Is that right?
Yes, I did.
Okay, go ahead.
I wanted to know if you get married, you get a divorce, and you have to pay child support, and say you missed a couple months and you're married again, or is your new wife responsible for your child support?
That is an excellent question. If you are working, the answer is no, assuming you're working to your full capacity. The court cannot, by statute, take the new spouse's income and use that for purposes of increasing your income for child support. What the court can do is look at the benefits that you have by virtue of having someone else support you. So that means that if your spouse now is paying the mortgage, for example, and you don't have a mortgage payment, the court could take that into account. But they can't take that new spouse's income and say, that's his income.
Okay.
So the answer is sort of.
Kind of, sort of, but not completely.
It sounds like the whole thing of this kind of law is sort of.
It's a little, yeah.
And it's always in flux.
It
seems
is.
like. Okay. All right. Next up we have Mary. Go ahead, Mary.
Hi, yes. My son and his ex-wife, they got a divorce. They had joint custody. Well, she moves, take the kids, and move to Atlanta. And we were just wondering what is it that he can do about that.
Has she already moved?
Yes.
Oh, he should have done something before then. He can ask the court to change his parenting time and perhaps take into account the fact that he now has a transportation expense. And if he was paying child support, he should probably get a break on that because he now has to pay just to see his kids or to bring them up here to see him. So it's unfortunate he didn't do something before she moved because he probably could have.
Can you make somebody stay?
Yeah, our court does it all the time.
You can make them stay.
You can. What you say
will they
is
make them come back?
Well, not likely. And it depends on what was in your agreement to begin with. If there was a prohibition against moving outside, for example, the state of Ohio, and the ex-spouse moved with the kids, that person's in contempt of court and perhaps could be made to move back. But if not, what our court often says is that the children shouldn't be impacted. If a parent wants to move, the parent's free to move. Nobody's ever going to say a parent can't move, but it doesn't necessarily mean the children go with them. It depends on the circumstances.
Okay.
Very good.
Right. And next up we have Betty. Go ahead, Betty.
Hi, my name is Betty, and we have shared parenting, but he has the title custody. so I have to pay child support. I've been paying child support since the first of the year. Is that correct? Or should I go back in and get it changed? Or can I go get it changed?
You've just said two things. You've said that you have shared parenting, but he has custody. You can't have both.
We have the same amount of time.
Okay, that's not shared parenting.
Okay.
He has custody. If he's the sole residential parent, legal custodian, he is the custodial parent, and you are not. And it would be typical that the non-custodial parent would pay support to the custodial parent. You would think that perhaps there would be some look at deviation if your time is pretty much 50-50 because you're picking up a lot of the expenses that that you might not pick up if you didn't have the children so often. For example, the transportation and buying the incidentals and all the meals and that sort of thing. I assume that the court took that into consideration. If not, they should have.
When they started the shared parenting business was post my involvement in domestic relations stuff.
Right.
What is shared parenting?
Shared parenting actually is the continuation of the legal status that you have when you're married as it relates to your kids. You continue to have legal custody. You are the legal custodian. That's what shared parenting means. People often think it means that your time is 50-50, and that's not shared parenting. Many people who have shared parenting also tend toward 50-50 time, but that's not the definition. It's who has custody.
And when you have a shared parenting circumstance, then is the support obligation equal for both, and therefore no support's paid?
No, because oftentimes they don't have the same income. So when they look at what the income is between the two parents, and if there's a big difference, if their income's about the same, they would not have it. But if it's different, there'll be child support.
Thank you for that. One, very quickly, how do domestic relations lawyers get paid?
On an hourly rate, usually. We usually ask for some retainer, which is a buffer, to make sure that we do get paid. And so it's an hourly rate typically.
And range would be in Cincinnati area more or less?
Oh, I guess maybe $100 for somebody who's just gotten out of law school and is kind of getting their experience, up to probably $450.
Okay, Barbara Howard,
Thank you so
much for joining us.
Thank you, thanks for having me.
Thank you, of course, for joining us here on More Law. We will be back next week talking about crime and punishment. We'll see you on Monday.